This video provides general educational information about adoption processes based on the laws of California and Texas as of mid-2026. Adoption laws are complex, fact-specific, and can change. This is not legal advice and does not create an attorney-client relationship. Every situation is unique. You must consult a qualified attorney licensed to practice in the relevant states for advice tailored to your circumstances. Hartley Law Group has attorneys licensed in California and/or Texas who can assist with matters in those jurisdictions. Do not rely on this video as a substitute for professional legal counsel. Welcome back. I'm Carla Hartley with Hartley Law Group. In this third segment, we're discussing two critical safeguards in the adoption process that protect the child and give the court confidence in the placement: background checks and home studies or evaluations. We'll also talk about when it makes sense to bring in your own private expert, especially in your more contested situations. These requirements exist in both California and Texas, though the specifics and intensity can differ depending on the type of adoption and the facts of your case. Once you've identified a child and begun addressing parental rights, whether through consent or a termination proceeding, the next major phase almost always involves investigation into your background and home environment. The purpose is straightforward but profound. The court and the state or county agencies involved must be satisfied that the adoption is in the child's best interests and that you can provide a safe, stable, permanent home. Background checks are universal in modern adoption practice. In both California and Texas, this typically includes criminal history checks, state and federal, child abuse and neglect registry checks, and sometimes fingerprinting or other screenings. I want to add a caveat here. Simply because you have some blips in your past, even a felony, as long as it is not a felony of the type that would prevent you being permitted to be around children ever, there's a possibility that you can adopt. We have performed several adoptions with stepdads or guardians who have had a blip in their past but have paid their debt, have gone forward, gotten great jobs, become active in their churches, become married to their current wife at the time of the adoption, and have moved forward with their lives. So don't lose heart simply because I've said there's going to be a background check. Talk to counsel, talk to experienced counsel. These background checks are required for you, your spouse or partner, and often other adults living in the household. The goal is to identify any history that could pose a risk to the child. Home studies or adoption evaluations go further. A qualified professional, often a licensed clinical social worker, court investigator, or approved adoption agency, will assess your home environment, family dynamics, parenting capacity, financial stability, emotional readiness, and support systems. They will interview your family members and sometimes references. In non-step parent adoptions, independent or agency placements, a full, in-depth home study by an approved provider is standard and required in both states. For step-parent adoptions, the process is often less intensive, but still involves important oversight. And this is an area where California and Texas rules show some practical differences. In California, the court generally orders an investigation in step-parent adoption cases under Family Code sections 9000 through 9007, with some particular focus on 9001. This is conducted by a court-appointed investigator, a licensed clinical social worker, a private licensed adoption agency, or another qualified professional, depending on your county. It includes interviews with the step-parent, the custodial parent, and the child when age appropriate, along with background verification and an assessment of whether the adoption serves the child's best interests. While some older statutory language addressed waiver, current practice in most California courts involves this investigation to fulfill the court's duty to protect the child. Since changes allowing private professionals, many families are able to complete this phase more quickly than in the past. In Texas, step-parent adoptions also require addressing the other parent's rights, and the court has discretion regarding an adoption evaluation or social study under the Family Code. In straightforward, uncontested cases where the child has been living in the home for a significant period and background checks are clean, many Texas courts will waive or significantly streamline the formal evaluation. However, local rules, your specific judge, or any concerns can still lead to a requirement for a full evaluation, particularly if we have an adversarial proceeding. Additionally, Texas law generally provides that the court may not grant an adoption until the child has resided with the petitioner for at least 6 months, although this requirement also can be waived if the court finds it is in the child's best interests. Here's where having your own independent expert can be invaluable, particularly if the termination of parental rights is contested or the case has any adversarial element. The social worker or investigator assigned by the court or county does important work, but their report is one piece of the puzzle, a big piece, but they may have limited time and resources. Retaining your own qualified expert, such as a licensed clinical social worker specializing in adoption, or a child welfare expert, or a child psychologist who is qualified to do custodial evaluations, will allow for a more comprehensive, in-depth evaluation tailored to your family's strengths. This expert can spend substantially more time observing interactions, especially valuable if the child is already living in your home. The expert can address specific concerns raised by the other side and provide detailed testimony or a report that helps the court see why this placement is truly the best outcome possible for the child. In those cases where we had an adversarial proceeding, and if your finances allow it, having the expert able to attend the entire trial to testify in his designated position or order at trial, and then remain, listen to all of the other testimony, and then at the end, as your last witness, testify that he's heard everything, address anything that opposing counsel brought up that would challenge or potentially cause the court to look askance at the county investigators' reports. That is invaluable because that makes it possible for you to have produced, by clear and convincing evidence, an expert's testimony which can overcome other objections. We often describe this private expert evaluation as the icing on the cake. It is not legally required in every case. It is not legally required in many cases. But in contested or complex matters, it is repeatedly proven to be the difference maker that gives the court the extra assurance it needs to make the findings we want it to make. In our final segment of this overview, we'll walk through court hearings themselves, from the proceedings to terminate parental rights through the joyful final adoption hearing, and why having experienced counsel at every stage is non-negotiable. We'll also share typical timelines so you can set realistic expectations. At Hartley Law Group, we routinely coordinate with trusted experts in both California and Texas to build the strongest possible record for our clients. If you're preparing for a home study or evaluation, if your case involves any contested elements, let's talk about how we can support you. Reach out through our website or continue with the rest of this series. We're here to help families in California, Texas, and those with ties to both states to build their families, their forever families, the right way. Thank you for watching.